Our session is entitled "The Legal Aspects of Implementation of International Compliance Standards in Russia." I will say a few words by way of an introduction into this topic. First of all, I would like to say about the term compliance as it stands in the name of our roundtable discussion. We, as professional community, see a lot of professional fora where they pay more and more attention and time to discussing these issues. The word compliance is used to mean different things from the professional and legal standpoint. From the point of view of legal technology, I would like to point out that the very word compliance has not yet been defined. Probably we are dealing with a conglomerate of norms and regulations which is dynamically evolving in the field of anti-corruption work. Probably this broadly defines this term, and at the same time we understand that this conglomerate of norms encompasses international aspects of anti-corruption work, anti-corruption efforts of separate states, and also the work carried out by companies and corporate entities working in one or several markets in the field of fighting corruption. They are trying to adopt appropriate measures aimed at counteracting corruption within a specific corporate entity. So from this long and winding linguistic definition, we can see that this is a very broad area. It touches upon all the sections and constituent parts of both international and national law today. It requires a certain economic background. It is related to the tax context, and of course it requires a very broad outlook. So this is a complex problem, and within the framework of our roundtable we will discuss this issue only from the point of view of legal practices. We're not going to say how topical this issue is. It's quite obvious at the modern stage in the development of our society. We can only discuss how we, practicing lawyers, can facilitate the application of appropriate norms and rules within our companies, within actors of the economic sphere, in order to attain the result of minimizing corruption and protecting our companies from this phenomenon. Also, through preventive measures inside the companies that will help those companies to create this feeling of being protected against corruption. So on this basis, our panelists will concentrate on various issues of legal practices. We're going to talk about due diligence, about personal data, about forensic investigations within companies, including anti-corruption investigations, about work with personal data. In this regard, we're going to discuss the possibility of using or not using various measures against workers of particular companies, what kind of provisions we have in the Russian legal system that will help to implement findings of such investigations, in particular with regard to a particular worker or employee. I mean labor law in this context. We're going to talk about antitrust aspects, where is the border between the two fields is not quite clear, and how we can bring both these spheres together so as to protect the company from various risks without infringing upon antitrust legislation. We are going to have a presentation on practical aspects of selecting third parties or partners. We will have a speaker from an international company, LexisNexis, who will tell us more about it, and he will tell us how they deal with risk management issues at their company. On this note, I would like to give the floor to our first speaker. This is Barry Vitu, who is partner from Princeton Mason. He's based in the UK, and he will try to tell us about international experience of carrying out compliance casework. He will highlight his own experience and probably share some findings that could be used in the Russian Federation. You have the floor.
Thank you very much. My name's Barry Vitu. I'm a partner at Princeton Masons. I also write a website called thebribeact.com. So it's all free, and you should read it. There's lots of free compliance stuff on it. Just to recap what I'm going to touch on first of all, I'm going to have a very quick look at the international scene, a very quick look at UK Bribery Act, and then I'm going to have a look at the impact of both those things on Russia and Russian businesses, perhaps with some lessons learned that I've learned over the years dealing with companies in foreign jurisdictions. Actually, there is only one lesson that I've learned over all those years, and that is that 90% of companies and 90% of lawyers get it wrong or look the wrong way. Okay? So I'm not going to spend too much time on the international scene and the UK Bribery Act. I suspect everybody attended numerous sessions on those over the course of the last couple of years or so. It's constantly, it seems to me, in the headlines. But we all know, I hope, that the Foreign Corrupt Practices Act is now sort of a big news story. Some big companies have had problems with it. At the last session, I think there were a number of those in this room. There were a number of those mentioned. For example, Daimler, Chrysler, Siemens. We've all heard of these cases, and they continue. So the US FCPA continues, I think, to be the market leader in terms of enforcement and the big driver for this whole anti-corruption movement, I think, over the last 20 to 30 years. The UK, some would say, we would say in the UK that we were a very reluctant bride when it came to anti-corruption legislation. It took us over 100 years to update our legislation from laws that were widely regarded to be not fit for purpose. We did that famously in 2010 with the UK Bribery Act. Who hasn't heard of the UK Bribery Act? Everybody's heard of the UK Bribery Act. I'm delighted to say we take it very seriously in the UK. We've so far had 3 convictions. Has anybody heard about the convictions? No? We've had a taxi cab driver trying to buy a license for his cab. We had, the first conviction was actually a Ministry of Justice employee who was taking £500 to lose people's driving convictions. And then the most recent one, which was a couple of weeks ago, was the son of a foreign public official who, having failed his dissertation at Bath University, which is a very nice Roman Bath spa town in the UK, went to see his tutors, his professors, who gave him various options so that he could remain on the course, which included taking his exams again. He offered them a fourth way. That was £5,000, and he wouldn't trouble them again. They asked him to leave. He did, and as he did so, a gun fell out of his pocket. He's in prison. But that was not, these silly little cases are not what the Bribery Act was about. And all I'm going to say about, and what we care about here, I think, in the international setting, is sort of the impact on corporations doing business. And all I'll say is that the UK authorities are undertaking a number of investigations. I'm aware of about 15 pre-investigations at the moment. If you're looking at this part of the world, but not specifically Russia, then a recent one which has just been accepted by the Serious Fraud Office is ENRC, Eurasian National Resources Corporation, which is a Kazakh mining company. So it's coming. These things have a lag time of, say, 2 to 3 years, but I think we will see some significant movement in the coming months. So that's sort of the international scene. So how does that impact on Russia? And if you're a big cynic, you might say it is practically impossible to get the evidence to prove corruption that takes place outside in a place like Russia or Kazakhstan, so why do we care? Oh yeah, and by the way, Russian nationals won't be extradited from the UK, and they're not captured by the Act anyway unless they live in the UK, broadly speaking, or they carry a UK passport. So that's all right then, isn't it? We can all pack up and go home. And that, unfortunately, or fortunately, is not the answer. There is a big impact on Russia, and it's not just on the law enforcement side, it's also on the commercial side. And that impact is basically this. If Russian businesses want to transact on the international stage, they want to raise money from international capital markets, they want to list on the London Stock Exchange or the New York Stock Exchange or the NASDAQ, or they don't want to do any of that, but they just want to partner with Western businesses as their agents or distributors in Russia, they are going to have to do some form of compliance, okay? And it seems to me that is where the real rub of all this is, because you may or may not be impacted by law enforcement, but it's almost certain and inevitable that you will end up being impacted by the commercial implications of it all. So what would I do? Compliance people typically don't have enough money to undertake their compliance function. I've never met anybody that says their budgets are enough. Sometimes their budgets are ridiculously low. And I know that we talked a little bit about what would we do in terms of onboarding, contracting with third parties. I'm going to have a little look at that as well, because third-party risk will be the big driver for a Western business seeking sort of compliance undertakings from a Russian business. They will also be the big driver for a Western business looking to set up in Russia, because they'll need help and they'll be worried that their third-party partner might get them into trouble. That's what creates this sort of domino effect, this cascade effect of compliance requirements, which manifests probably in a lot of very boring boilerplate provisions in an agreement. So against that backdrop, if I had, say, 2,000 rubles, not very much money, right, to onboard a third party or to look at a third party relationship, and if you ask some compliance officers, they'll tell you they wish they did have 2,000 rubles to do that. Most people spend the 2,000 rubles doing something which is probably the least important thing, right? And then it all turns into a horrible mess later on. I'm going to guess that the average company that is concerned about a third party, a distributor or an agent, which perhaps is something that one of the Russian businesses here might be, their big question is going to be preliminary in most cases. What do we do to onboard, to sign an agreement with our new partner? That will be it. They will spend 90% of their time worrying about that, and perhaps only 10%, if you're lucky, on what happens afterwards. And my basic thesis is that's basically completely the wrong way around. You should spend, if I had 2,000 rubles, I'd spend 200 getting them in the door, and I'd spend the rest working out what the hell it was they were doing once they were my partner. Because it isn't relationships which cause problems for corruption perspective, it's transactions, right? So I'll give you a very quick thumbnail sketch of what your average onboarding process looks like, or should look like if somebody's really on the ball. Probably you'll have a questionnaire. The questionnaire will cover all sorts of things like beneficial ownership, public checks, all that sort of stuff. And if you're on the ball again, it will throw people into different buckets of risk: high risk, medium risk, and low risk. And in Russia, there's a chance you're always going to be in the medium to high because it's a risky jurisdiction. Okay? And then if you're really lucky, if you're in the high risk bucket, there'll be some sort of committee, this is the Western company perhaps, that then says, well, what are we going to do now then, because they're very risky. That's all fine, but actually there are sort of three golden rules, I suppose, if you're onboarding someone that I would look at on top of all those things, which is, what is the commercial purpose of this relationship? What are the services that they're offering? Are they going to deliver those services? And are we paying fair value for those services? And broadly speaking, if the answer to all those questions is the right answer, then you've eliminated probably 80% of your risk right there, haven't you? Because the real issue with third parties and weeding them out is you want to weed out the fake ones. I mean, what I see when you are talking about corruption in a practical context is somebody somewhere has to pay a bribe. To pay the bribe, they end up having to extract cash from a business, and they do that normally in one or two ways, either inflated invoices or in the context of fake third parties. So at a very base level, when you're onboarding a third party to kick off, you want to weed out all the fakes, don't you? And you don't need to do a lot of hard work to weed out the fakes, in my experience, because sometimes working backwards, so I'm faced with a marketing services agreement between two parties, and I look at it and I say, well, who is this company? And it's suddenly very surprising, it's surprisingly hard to get any information about it. It's a faceless offshore company, there's no phone number, the people's names are interchangeable, you can't Google them and find any of these people. Have they got a phone number? Is it a Gmail or a Yahoo or a generic email address? You know, is the address, if you Google Earth the address, do you get to an office block? Or do you get to an apartment block? Or do you get to not very much? I mean, these are all very basic things which you could do for nothing to try and which would immediately eliminate a significant amount of risk. So, but I guess, so you should have a process. There probably should be a high, medium risk and low, and you should have some questions, and they should include things like that and also beneficial ownership and stuff like that. But that deals, assuming that you've got rid of all the fakes, you've worked out you're not dealing with a government minister, and it all looks sort of okay, then you're basically ready to go, aren't you, with your third party? And that's the way that a Western business should be looking at partnering with businesses here. And so the next question is, well, what is it that you guys or a Russian business needs to do, or that a Western business will and or should expect? And in that context, I'm going to focus a little bit just on a few headline issues which I think people should do during the pendency while that relationship is ongoing. Okay, and some of it's really simple stuff, but it just doesn't get done. And then people like me and other members of this panel have to come along and try and pick up the pieces. But there should be somebody who's in charge of that relationship, who's keeping an eye on it, who's monitoring it. There should be, maybe you should set up some KPIs around the service levels that you expect. So, for example, if you have a marketing services agreement that's fake, I'm prepared to put money, and this isn't just a phenomenon here, it's a phenomenon in the UK as well. People they're not very imaginative about the ways they use to extract cash to pay bribes. I bet you, if you ask to see, where are these marketing services, show me some materials, show me a brochure you prepared, you won't get an answer, because it doesn't exist. It's totally bogus. I would expect, if it was me advising a Western company or I'm advising a Russian company, and I do both, what training is it? What training is it that the business is giving to its own employees? You can measure how likely it is that this business is going to create a problem. If they're not giving their employees any training in an environment like this, it's asking for trouble. What does their ABC look like? What does it, and think of it and look at it from a very, like a regulator would look at it, okay? So if there is no training program, if there is no anti-bribery and corruption compliance policy, you know you've got a fairly steep hill to climb to help the business come up with some form of compliance. But you should be looking at that like a regulator would look at it. Audit rights. I'm not a huge fan of audit rights, but if you've got them, you should exercise them. One of the things we got here. I think one other thing I'd like to touch on is just transactions. I started all this off talking about transaction review. It's really important that the person in charge, the CCO of a business, the chief compliance officer, if there is one, or the general counsel, or the internal audit person, understands how the business operates. You need to understand the sorts of transactions the business is doing, and only when you understand that can you then understand what transactions are out of the ordinary or shouldn't be taking place, and where you should be focusing the attention. Okay? So thinking about a specific third-party example, you might want to say, set some parameters, some boundaries about what sort of transactions they do. And then you look for the outliers, the things that don't look right. You might also just set some, just do some random sort of auditing from time to time. Are you going to, every 100 transactions, you'll check one? I don't know, but that sort of thing. Set some rules and do it. And then finally, well, not finally, I've got a couple of things to say about terms and conditions. As a lawyer, you would expect me to. But I think you want to make sure that the internal audit people are trained up to know what to look for on invoices. They will look at invoices from a process perspective, but they probably won't look at them from a more interrogative anti-corruption standpoint. And so we need to make sure that they are trained up to know what to look for. Now, I've spoken for a bit too long, and I'm a lawyer, and I haven't even touched really on terms and conditions. Why is that? Because in all the years I've been doing this, they're very important, you should have them, but I've never met anybody who's a criminal, a crook, or a payer of bribes who won't say they don't pay bribes. They're quite happy to lie, in my experience. And likewise, they're also extremely happy to sign an annual certification confirming that they haven't paid any bribes. So while you have to have these things because a regulator expects them to happen, I would focus, if I had my 1,800 rubles, on monitoring the relationship with things like I've just described and blow the other bit on the onboarding of them.
Barry, thank you very much. Very short question, just like yes or no. Do you believe analysis of anti-corruption programs and basically dealing with anti-corruption is a legal profession or not?
It's a legal profession. I think.
No, not patient, but profession. Is it legal profession or not?
I think it's. I think it's yes, and other professions as well.
So basically, legal in the core, and then with other backgrounds.
Yes.
Okay.
I think.
But you do believe that legal shall be in the core?
Yeah, I'm a lawyer. I'm doing it.
Yeah, that's what we do believe, but we see different approaches. Господа, thank you very much, Barry.
Our next speaker is Mr. Andrei Ross. He is the Director for Forensic Technology, Fraud Investigation and Dispute Services of Ernst & Young. And Andrei, this is such a long title, I was struggling to say it. Thank you so much for the introduction. I will try and deliver my presentation in English because it has a lot of technical terminology. So regarding my title, you can describe it in 2 words. This is the investigation and technology. So we use technological advances and new technologies in order to run our investigations and to do our forensic science. So this is the essence of my title. I think you'll be able to see my presentation on the screen shortly. Could you please display the presentation on the screen? But to generalize, what I'd like to say is that legal efforts the legal efforts to prevent fraud are extremely important, but since we are all realists, we do not live in an ideal or utopic state, and we all know that if you just develop the guidelines but do not see to their implementation, so they become non-enforceable and nobody will adhere to them. And another point which I would like to make, big data, actionable intelligence.
Big buzz terms, big data. What is big data? Big data is all the information that your IT system already have on your corporation accounting system, emails, marketing, HR. You got big data. If you look the amount of data that you accumulate every year, it will be terabytes of data. It's a very, it is very big data, I would say. The problem with this term is that what do you do with it? And I mentioned actionable intelligence. That's exactly what you should be doing with this data. You need to look at it. Yeah, I'm just speaking about technology. Okay, here we go. That's basically what I just mentioned. You need to do real steps to fight the corruption. And you need to be careful not to become a big brother. You have to be careful not to monitor every step of your employee. You have to be careful to stay within the legal framework. You have to be careful and stay within moral and ethical frameworks as well. Speaking about technology again. Okay, we'll give up. Okay.
That was a short presentation. It didn't work. We have to.
That's all right. Don't worry about it. Now, the big data that I mentioned is just a bunch of files. They contain some information. There is a difference between knowledge and information. And information is basically a description of something, accounting data, etc. Knowledge is something that you look at the information from the different sources usually and come up with a new information, but that information you can act upon. An example of being, if you look at the, for example, just a simple example, weather in St. Petersburg. Obviously, it's rainy days very often. It's during the summertime. It can become quite windy and cold. So that's information. The knowledge is, if you travel to St. Petersburg, you'll probably realize that during the day, the weather can change 10 times. This is also information. So what do you do? You got the knowledge that the weather in St. Petersburg is treacherous, so you take an umbrella. So this is your knowledge. The thing is, Analyzing this data until, say, a couple of years ago was a big problem. You had to buy a big server, you have to load everything, you have to learn how to look at different data, say email, PDF, Word documents, Excels, etc. And it posed a big problem. Then you need to come up with an algorithm. Today, technology exists, and my message, and it's quite provocative, it's finally on the screen in blue. You basically sitting on the knowledge, you have all information that's needed to identify and investigate corruption. And there is no reasonable excuse not to act. And I'll give you an example how this information can be worked with. Imagine that you have a big vendor list. You got HR database. Then everyone probably heard about information providers such as Spark, Integrum, LexisNexis, by the way, one of them as well. It is today possible to load everything into a program, and I'll give an example, I2. There are a big list of programs that software capable of analyzing the data. But essentially what you do, you load the vendor list, HR database with all your workers, all their relatives, and then you get information from Spark on company, on their directors, on their associates, and it'll become a big mess with, I would say, on the first level, if you look at the first level connections, identifying connection between the company and vendors, it might be 1,000 companies. The second level will be around 20, 30,000. The third level, if you're going deeper on examining, will be 300, 500,000 companies. And it'll grow exponentially. You need to know where to stop, and this is a decision that needs to be made during the initial setup. But from our experience, 3-4 levels deep is sufficient. And this information will find matches between, for example, you vendors by themselves acting together on a government auction, trying to defraud the government by bidding against themselves, and they will have the common directors or common, even a common phone number, that a mobile phone number that they use during the registration of the company. So we can identify this and produce, in the end, affiliation chart, saying that this person working, say an accountant in your company, his wife or her husband works as a director for your vendor, and this vendor also has 3 affiliated companies. So then you need to look at the your sales figures and see and analyze what's the benefit of working with this particular company, what's impact with working with this company, etc., etc. But again, the problems here I can see is what do you do with this information, because this is not something that you can bring to court. Often it's just a chart or a graph saying that there might be affiliation or the company might be losing money. This is the information you created. It's not something that you can often easily explain to the judge, for example. So this is a newly created information, and my colleagues, I hope, will comment on it. But the key message here is again, there is no reasonable excuse not to act on this information. At least you will understand what's happening with your business, what affiliations your company have, potential problems, etc., etc. And with today computing power that is increasing every 2 years, doubling, it doesn't take long to process all that data. So basically, I'll pass this. Yeah.
Just one
the
question.
word on
before you-
microphone to my colleague to comment on legal aspects of it, but from the technical point, that's where we are.
Just a few questions, not few, just one. We must get out of the beginning of the presentation when you said your controversial statement that there is no excuse of not to act on that data. It looks like you believe in checking the data is like a preventive message. It's like, it looks like, you wake up in the morning as a manager of the company and say, okay, why wouldn't I check the emails of all my, colleagues? And I believe from legal perspective, it's not what we are talking. We're talking about that there is a cause of looking for some specific information, and that's where your kind of services are stepping in.
Well, checking emails is a little
There are
bit
different,
different
of course,
area.
reasons,
Yes.
but we are talking the check on the reason rather than to check preventing and finding the reason.
Yeah.
Yeah, okay. So then сейчас мы передадим...
Well, now we're giving the floor to Mr. Nevzorov, who is manager of the legal practice, senior manager of the legal practice of Ernst & Young. So talking in legalese, well, he'll be speaking legalese. And he will expand or build on what Andrei Ross has already said.
Okay, colleagues, good afternoon. Information is a key to everything, and my presentation will be about Russian and European specifics of data analysis for investigations into fraud cases and other negative issues. If we take information processing, we will see that there are three major sections of legal rights or legal aspects that regulate data processing. There is always a balance between the interests of a company to get access to data and investigate a fraud case, to learn that an employee divulge commercial secrets of the company and punish him accordingly. So these three units of legislation are legislation on personal data, on the confidentiality of private life, and the third part of legislation is legislation on intellectual property. Usually we deal with these three legal components when we talk about information processing. On the slide you can see what we have in Russia and what may be used by companies in order to investigate, in order to discover various issues. Legislation on personal data. Here we should point out that on the 15th of May, the day before, yesterday basically, when talking about compliance of Russian legislation to international standards, the Council of Europe received the ratification of the Russian Federation, ratification of the old Council of Europe Convention on the Protection of Personal Data. Now the Russian Federation is at the level of protecting personal data that is characteristic of other European countries. There will be, of course, amendments into appropriate laws, but now we have attained a certain level, and if we take processing of personal data and the standard case, this is done when the employee gives a consent to process personal data. Sometimes the law allows you to process personal data without obtaining a prior consent if you need to protect your rights, attain your own legal interests. But if we are talking about fraud, discovery of fraud cases, this is exactly this case. What Andrei was talking about, information from open database, from PARC, from other databases, we can process personal data from there. Another aspect of data processing is processing of personal data from the point of view of legislation on personal individual rights and individuality of correspondence, confidentiality of correspondence. Can the company check emails of their employees and identify various signs of possible fraud? There is basically a collision of legal norms. There is the right enshrined in the Constitution that correspondence should be kept secret. There is the European Convention on Human Rights and Freedoms, and Article 8 tells the same. But if we take, for example, the Copeland against versus the UK case, and I will explain how this case could be implemented in the Russian legal system, how a company, without infringing upon secrecy of correspondence, can study emails sent by the employees. If it turns out that when we process data and we obtain know-how of third parties, which turned out to be accidentally in an email or in the database, the rights which haven't been given to the company. So another issue is that the employee can demand that we stop this infringement on a third company may claim that we had obtained this access to their know-how in an illegal way. We haven't seen such disputes so far, but theoretically they can exist. If we take European experience, we will see that Europe is quite like Russia, not only because we signed the convention, not only because we signed the European Convention, but also because of the principles that prevail here. And here, Copeland versus the UK of 2007 is a key case. The European Court of Human Rights ruled that all information that exists on the computer of an employee, and all, including his email correspondence, is personal data of this employee. Company cannot intervene and analyze this data. But there was a very important caveat made. Without his or her knowledge. So if the person in question was not aware of the fact that these data were processed by his company, there was a court case in Austria, and the decision was quite similar. Copeland versus Russia, whether the company can control the email correspondence of their employees. Here we have a contradiction between laws. There is a general rule in the Constitution that private correspondence should remain confidential. It is part of the confidentiality of private life. And these rights can be, restricted by other laws that would be enacted in order to protect public interests, public morals, and so on and so forth. But we have the European Convention, which also has Article 8, which guarantees the right for confidentiality of private correspondence and private life. And there is also the decision by the European Court of Rights, which says that if the employee was aware of monitoring, then monitoring of his personal data becomes possible. The Constitutional Court says that the case law of the European Court of Human Rights is an integral part of Russian legislation, and therefore they apply directly. And here the right for confidentiality of correspondence are restricted not by a federal law in Russia, but by an international instrument, the European Convention, which came into force in Russia after its ratification, and here we do not have any violation whatsoever. We can go back to European practices and see another case, Berlusconi. There the question was whether international treaties could restrict or limit individual rights of people. The answer is that the secrecy of private correspondence can be limited if with prior information provided to the employee in question, and this information may be processed. For example, if we are dealing with cases of fraud or conflict of interest. In conclusion, I would like to give you an overview of case law of Russian courts, what they use as evidence that evidence that was obtained as part of the personal information, personal data analysis. All the data from open sources is an acceptable evidence in court. There are lots of cases where companies hold their employees liable, where the transactions are considered to be not at arm's length transactions. And here, personal correspondence may be used as an evidence of the fact that this or that transaction was not at arm's length one. Now that Russia joined the convention and introduced appropriate standards, we hope that the Copeland case will be widely used by Russian courts of law, and then we will have an adequate balance between the interests of employees and the interests of companies in preventing or uncovering various cases of fraud.
Thank you very much, Igor. I think that was an ideal presentation. Such short time, so much information. Well, but using my rights as a moderator, I'd like to comment on your presentation from the point of view of a corporate lawyer. I'm not advertising anything or anybody, but such a consultant who can use who can deliver so much information per one billable hour is great, but probably not for the interpreters, but for everybody else present. So, dear colleagues, that was our vision, the vision of our panel for the processing of personal data and the use of data in investigation. And right now, we would like to ask Anton Smirnov from Hugen Lovells to tell us about the aspects of labor law when something either fortunately or unfortunately is discovered. We have to do something about it under different laws, both corporate and laws that apply to corporations. So how do we do it? And one can get in our way. Thank you very much, Aleftina. We heard about different stages of compliance implementation. Barry told us about using compliance before choosing a business partner or during onboarding. Andrea told us about internal in-house investigation. And I would like to tell you about something else. So the internal investigation is over. Then what do we do about the employees that got caught red-handed or are suspected or who are caught in the middle of a corruption deal? So well, here the wishes of an employee contradict the norms of the Russian law, and I would like to tell you about such contradictions. Well, from my practice, the first thing that a compliance officer or a general manager of a local division wants to do once they see that an employee is violating the law, well, they want to fire such an employee so that, they can move further. But then here they are faced with a number of very serious challenges. Well, first of all, as you all know, we cannot really fire anybody for corruption. We can only fire them only when there is a sentence that found them guilty from a court. And of course, there is not a single company in the world who would go and tell the regulators, about it in order to fire one or two employees, especially taking into account that we have article number 1928 of Administrative Violations Code, which imposes a fine for the company going up to the amount of the bribe multiplied by 100. So when a compliance officer hears about it, he might say, let's hire such a person for violating corporate policy and corporate rules. We do have it published on their website, and it clearly states that bribes are prohibited. But here it raises a number of other important questions. Well, first of all, from the point of view of the Russian law, an employee can have a regulatory act, and such a regulatory act is deemed legal. It should be something that is ratified by a decree by a department, and it should be signed by an employee. Therefore, everything that is published on websites, and sometimes it is not even translated on an internal portal of the company, it just says corruption policy or ethics code, and it just gives us a general outline. So all of this is not considered as a local regulatory act of an employee, and for violation of this policy, you cannot really fire anybody by saying that such a person violated their obligations as an employee. Then another thing, Russian labor law protects the employee, and you can only fire somebody for a single violation only in the case when they're absent from work for 4 hours in a row or when they show up drunk. Therefore, violation of corruption policy is not such a case and does not give us a substantial reason to fire an employee. We can reprimand an employee, and after that we have to wait for another year for them to violate the law one more time. And if failing to do so, the employee is free from disciplinary action. There is another thing. American regulators, Department of Justice, as a rule, they do not want the company to fire the guilty employee straight away. They want a company to make those employees available in case they need to interview them or something else. But the only way for a company to keep such an employee is to keep their job. So, okay, we cannot fire. There is another option, which is, as I know, something that foreign regulators insist on: suspend such an employee from work so they do not have an opportunity or a possibility to make corruption or to violate anti-corruption policy. But that again poses a certain difficulty because, as you all know, Article 22 of the Labor Code of the Russian Federation stipulates that the employee has to provide, and an employer has to provide the job to an employee, which is stipulated in their labor contract. So the employer should not only pay the salary to the employee, but it should also give the employee an opportunity to work and enable them to do the job that they agreed for. So the garden leave does not work. The garden leave policy does not work in Russia. But I can tell you that in ex-USSR countries, Middle Asia, Kazakhstan, Kyrgyzstan, they have a better situation in this regard. They assume, they believe that the salary or the compensation is something that an employee gets for their work. So the only thing that they can demand is the salary or the pay that they get for their work. Therefore, if you keep the pay but do not give an employee an opportunity to work, then an employee cannot do anything. Well, in terms of everyday practice, this is better for a company that is running an internal investigation. So what do? We either have to reach an agreement with the worker and we have to reach an amicable resolution or terminate the contract on the amicable ground, or we have to reduce the headcount, because if somebody is made redundant, then you have to offer them all existing opportunities for work that you have, and only when and if say you have a single mother on staff or a pregnant single mother, then it is impossible. Therefore, Andre asked a question: information versus knowledge.
Во-первых, Трудовой кодекс знает такой.
Well, first of all, the labor law knows such a thing as revision and amendment. Therefore, we can take a disciplinary action towards an employee, not from the moment of violation, but once the revision is complete. On the other hand, my experience tells me that foreign regulators really love emails, and they have good experience in how and where from was this email received, what sort of search engine was used to extract it. So here, I agree that if we said that the company had knowledge only because it had 500 emails on their servers that were related to corruption, we probably cannot say that. But once the investigation is over and the company has the knowledge, then we can say that the knowledge is there, but whether this knowledge is enough for Russian courts to fire an employee or to lay an employee off, then we can say that it is not enough. We have to take a whole array of different actions. So I have to agree with my colleagues here, and I agree with Alevtina that compliance, the way that it is in the West, this is something new. We do not even have a term in Russian that would define this area. But I think that in time we'll manage to reach something, to reach the golden ratio, because as you know, 1,000-mile road starts from one step. And I can tell you that it's not just us who don't have it as a term in our language, compliance, but we can say that compliance is an informal term in the West. Compliance, something describes as norms. I don't think that anybody has an exact term, and I think that we, being a professional community, we have to pay very close attention to this, because we now take active participation in the emergence of new norms, and therefore we have to structure this quasi-institute in the right way. Dear colleagues, our next speaker is Boris Yedidin, who is a representative for the Russian Supervision Board in Mass Media and IT, Roskomnadzor, and Boris is head of the legal department in the service. So as you remember, in Russian law, this is a body that protects personal information as part of its job. Thank you very much, Alevtina. I just wanted to say that compliance is one of the instruments to fight corruption, and adherence to law about the protection of personal data is something that we have to use, and it is mandatory for use, so that we can use the results of internal audit in order to take action against a guilty employee, or in order to change corporate behavior. But what Barry and Andre said, I wanted to note that, well, for us being a supervisory body, for us it seems sometimes as pushing some boundaries, and if we talk about big data, if we talk about a huge volume of information, which might also contain personal data on people who are not directly linked to the company, but personal data about people who are removed by 3 or 4 links from the company, then here we have to face the issues related to supervision and adherence to law on protection of personal information. So here I think the problem is that current legislation, both national and international, since it was developed some time ago, it does not take into account the real situation about information turnover and about exchange and personal data. Therefore, the legislation limits us in a very serious way when it comes to processing of personal data, and it impedes the companies in their internal investigation, in their fight about real threats to the profitability of the company and the transparency of the national economy as a whole. That's why I would like to talk about certain complications that we have to face with the definition of the operator of the personal data, of processing of personal data, and the issues that we have to face when working on certain directions, the issues that our regulators have to tackle in order to ensure that the implementation of compliance in Russia. So the first issue, what is personal data? Well, personal data or personal information, both under international and the national law, it is everything that is related to a citizen or helps us to identify a citizen. Therefore, when we face or we have such questions such as whether the information is obtained from open sources, from the internet, whether it is personal data, then again, we have to ask ourselves a question. So the name, personal name and family name, say that membership in a cat lovers club, passport information, identification. I think that for our legislators, all of this information is the same from the legislative point of view. So both for law enforcement and for the regulators, it doesn't matter what it is that you're processing, whether it is the name and the family name, or whether it is the information that somebody is communicating with somebody and they have a certain email address, or whether somebody's passport details or information about their private and family life, whether it is the information, what sort of position does this person hold within a company. So for them, it is all the same. So here, let me give you an example. It is quite often that the business press publishes information about CEOs. Then this information ends up in analytical agencies who provide this information acting on request from business partners, and sometimes some say the picture is wrong and is not match the name, or the bio is wrong. Therefore, in order for us to understand whether it is or isn't personal data, whether it should be regulated from the point of view of law enforcement and the regulator, it is extremely complicated to understand. That's why we would like to see amendments to the current legislation, because if it is amended, then we can categorize personal data. We can categorize the knowledge or the information about personal data. We can categorize the possibilities of the potential use of such personal data, and therefore we can point the regulator in the direction of the personal data which calls for special control from the government. As I've said, personal information can be very different, and the operators who process personal information, they are also extremely different. We have large companies, we have banks, we have insurance companies, we have huge holdings who process all information about a citizen, and say when somebody wants to obtain a loan, they provide their family information, they give information on their family members. I think everybody present here knows what sort of information a bank asks for. On the other hand, we have companies or non-profit organizations who do not process personal information as part of their everyday business operations. But today, our legislation is such that all of these companies have to adhere to certain requirements when it comes to processing of personal information. They have to obtain consent from people who enter into legal relationships with the company. They have to adhere to requirements related to collection and storage of personal information. And we think that one of the directions in this area should be categorizing of subjects or operators who process personal information. In order to do so, we have to define target audiences. We have to define the set of criteria that would allow us to define operators who process important personal information, who process sensitive personal information that should be regulated publicly by the state. And on the other hand, companies who process personal information and do not transmit such information further, do not transfer it to third parties, then such operators should not be controlled by the government. So, in relation to this, I can say that currently Russian legislation has a very blanket policy to all operators who process personal information. But if we talk about specialized categories of operators that I've mentioned before, such companies for which personal information is essential for their business operations or a part of their business model, these companies have to have industry standards, and we would like these industry standards to be developed for specific industries. Here we looked at international experience, and we realized that this experience can be used to introduce certain behavior codes, certain personal information processing codes for each of the sensitive areas. I can say that in the USA, they do not have a single law governing personal information, and the regulation of these relations is done on an ad hoc basis. And in Europe, which has a convention, which has an EU directive when it comes to processing of personal information, then Europe still uses self-regulation. They still maintain codes of processing of personal information in certain industries, such as internet, shopping, and so on. We think that the approach that I described would, on the one hand, decrease administrative costs for the companies that do not process sensitive personal information, and on the other hand, that would allow us to develop very clear procedures for the companies for which it is a key business activity.
And now, another aspect of processing personal data that I would like to reflect upon. Processing of personal data involve all actions related to personal data. And in practical terms, Russian companies, especially big ones, or branches of transnational companies, they have questions related to three main problems. Problem number one is the involvement of organizations that has to provide some services to this company in terms of human resources management, in terms of recruitment, in terms of tax reporting, in terms of other things. How can we as regulators approach such outsourcing activities? We think that processing of personal data by companies, which is carried out in the interests of the company, and the data that are used are not transmitted to external third parties from the company that receives personal data. This is processing of personal data within a company, and this doesn't require any consent or adherence to specific requirements in this field. Another case is when personal data are given over to entities that use those personal data acting on their own behalf. The most vivid example is the work of collector companies. So the company that receives personal data directly, if they represent the interests of the first company in the tax authorities, in their relations with counterparts, we think that in this case, such a transmission of data requires consent from the person in question, and the operator of personal data, such a company I'm referring to, well, is an operator of personal data. And another aspect related to personal data processing that we often come across in our practical work is transborder transmission of personal data. Here I would like to draw your attention to the fact that you need to comply to three conditions if you decide to send personal data to other countries. Number one, you need to define national regime of personal data processing. You need to define the status of the entity which receives personal data and whether its activity is in line with the national legislation of the country having jurisdiction over this company. Therefore, transmission of personal data over the borders, and Russia now is party to the Convention of the Convention on the Protection of Personal Rights. It allows the transmission of such data to other parties to the Convention, and there is also a list of 19 countries who are not parties to the Convention, but still they are considered to be countries where the protection of personal data is at the appropriate level, and the Russian legislation allows transmission of personal data to those countries without any additional requirements. Maybe my presentation was not very well structured, and maybe when I was talking about what we are going to do and how we interpret existing regulatory instruments, but summing it all up, I would like to say that major trends should be as follows. We need to classify personal data. We need to define those data that are sensitive and require regulation by the government and that require special protection at the level of legislation. Another area is classification of entities who process personal data, and we also need to create industry-wide standards for the processing of such data. So we need to combine here both government regulation and self-regulation. So the problem that we are faced with is that it is very difficult to define areas in which appropriate standards can be formulated. It is very difficult to bring together market participants so that they could create such a standard. And the third trend I would like to highlight: facilitation of mechanisms of personal data processing and information circulation in the broader sense of this word. Thank you. Well, we have some time for some questions and answers, but it would be better if we have questions at the end, because we have two more speakers to listen to, but we will come back to questions. I have a question myself about self-regulation in the field of personal data, but probably we'll come back to questions later. I would like now to give the floor to Managing Director of LexisNexis Business Information Solutions, Mr. Robert Veneboer. He will share his experience working in the Russian Federation and tell us how they resolve practical issues connected to their work in this country, how they select counterparts.
Thank you very much. I hope the presentation can be put up. Okay, let me start. My name is Rob Veneboer. I'm Dutch, hence the accent. I'm not a lawyer, but I'm a managing director, and I take this issue as from a more commercial point of view, more from a business point of view. We sell across Europe. My business unit is selling across Europe legal and non-legal information to large corporations, government, and we do that almost in every European country, including Russia and the Middle East. Of course, we don't have offices in every country, so we use partners for that, resellers. And for me, checking out resellers and partners is quite an important task. So I will not talk about the full risk and compliance program we have in our organization, because we are totally over it, because we are in essence a US company. But I will focus on that part of our program that is about relationships with partners, and focus on how we avoid involvement in anti-bribery and anti-money in money laundering. So the topics I want to touch on is, let me see if this works. No, that's the wrong one. Yeah. Is who we are, what we do, just very brief. Why is it important to us? What is our process for onboarding key suppliers or partners, for that sense, and how we check, our partners using public available sources, and what are the limitations using public available sources? And then on the last slide, there's already mentioned a lot of stuff, so I will keep that very short. We are part of Reed Elsevier, and probably after Thomson Reuters, we are the largest publisher in the world. We have LexisNexis, the bit of Elsevier is our science publisher, and Reed Business is our business publications publisher, and LexisNexis more or less the publisher of legal. It's actually, the company is divided in two pieces. One is legal and professional, the other one is risk solutions. So we are very active in that area. We have 3 million customers across 175 countries. We do 1.9 billion euros of revenue. We have stored in our database more than 5 billion documents, and we process 3 million queries a day. We have about 33,000 different sources. So our core business is content, and it ranges from own content to web content, licensed content, social media content, to very hard data, statistical data for various sources. And the key thing is that we use technology to deliver specific information products to specific markets. And in my business unit, we focus on legal research, we focus on risk management, we provide tools for compliance and reputation management. So why is this for us important? Well, of course, we are a public listed company on the stock exchanges of New York, London and Amsterdam. And we are subject to all kinds of laws, and especially the laws of the US, the Foreign Corrupt Practice Act, UK Bribery Act, already mentioned with the previous speaker. So enough reasons for us to take this very seriously. And also, compliance incidents, even small incidents, can have big impacts, financial impacts, commercial impacts. These are a couple of examples I always like to use because they are so big. These are just a few examples. I know the actual list is much longer, and actually the number of Siemens is double this, because this is the only the fine they got from the US. They got another one from the German authorities of 800 million. And so they got a fine of almost 1.6 billion. And I just read an article about Siemens that they actually incorporated a law firm in their own company to ensure that all these compliance processes are well managed, well implemented, well monitored. And I see that more and more growing, also in our company, that we are hiring lawyers, law professionals to ensure that I, as a business manager, is implementing these processes and are maintaining the relationships with parties in the right manner.
Just a few words about Siemens. The latest information, they have hired 500 lawyers working on compliance after that nice
and mostly, what I found really interesting is that their budget for outsourced legal work went down. So
with 500 lawyers, it's a luxury,
Yeah, absolutely. It's not working. Can you switch it to the next slide?
Вы не могли бы включить следующий слайд? Не работает пульт.
Well, the other slide would show that apart from getting a fine from authorities, if you are a public listed company, you can lose a lot of value. This is the example of Finmeccanica, where the CEO was involved in a bribery and went to jail. The value of the company on the stock exchange sort of halved, so it's 50%. And if you compare the bottom one, it's the comparison with their competitors. Well, their competitors are very happy. I can assure you that. And in my country, in the Netherlands, just a couple of months ago, an engineering company called Emter was involved. One of their managing directors in Germany was involved in a bribery to get a tender, to win a tender in Poland. And within 3 hours, their stock went 50% down in 3 hours, and it never recovered till to date. So there's a huge impact for public listed companies if you get involved in any sense in bribery or in anti-money laundering. So apart from that, we are established in countries where we see an increase of new regulations around anti-money laundering and corruption. So there's a lot of pressure on us to make sure that we implement the right processes. And the last slide on this is that, on the why is that we are increasing our investments in countries where there is a higher risk profile. So it's evident that we need to implement these processes and maintain them well. So what is our process? It's very simple. The first step is we do an initial due diligence. We use our own, we check what we already know. We send out a questionnaire to the partner. He has to fill it in, and these questionnaires focus on getting good sight on ownership, their performance, and also we will ask a lot of questions about how they implement their compliance processes, how they check their suppliers, and we ask for references if it's a new partner. This process, we will do that every year, especially for the partners in high-risk countries. So in December, I spent like 2 weeks to do this work. If the first step leads to a red flag, then we do an enhanced due diligence. And then in enhanced due diligence, we look at 4 buckets. Depending on the red flag, of course, we will not check everything, but depending on the red flag, we sort of see 4 areas of risk: financial risk, reputation risks, regulatory risk, and other business risk. And we can do all kinds of checks. And we are fortunate that we have our own system. We have a lot of data we can use ourselves to do these checks. It is not as cheap as 2,000 rubles, but it's not a big investment, and I think it's very wise to take these kind of steps, these kind of checks. And the content we check is of course the web, content from aggregators like us, and from information brokers, like Dun & Bradstreet, for instance. What is actually quite interesting in this one is negative news search. Because based with our analytics software, we can sort of get an early warning kind of information around companies or markets or issues. So it's quite that check is quite well used by our customers as well. And if we still have a red flag after the second step, then that's depends on what the red flag is. In most cases, we will probably stop the relationship. We will not continue. And if we have doubts about the quality of the information we are using to make this assessment, or we question actually what is the red flag, then we ask to a specialized screening agency to do a thorough investigation. But I can assure you that is only happening once in 5 years. We probably will stop. So what are the limitations of public available information? Well, it's already mentioned in the previous presentations, but there's a couple of things you should bear in mind. First of all, not everything is available. If you use Google to do your compliance, good luck with it. There are laws and rules, and it's already mentioned, that restrict access or use of information, of content. There are rules around data privacy that limits the use. The personal data is already mentioned. Another problem is the quality of the information on the open web. It's not always good. It's diverse, very inconsistent. Content is not updated or maintained. And this is quite an interesting point. There are limitations of search engines. I'm not sure you are aware of it, but the European newspaper publisher is starting an antitrust lawsuit against Google, because Google is favoring their own content in their algorithm. So that means that if you Google, you're not sure you get the right order in terms of relevance. I'm making this a little bit bigger than it is, probably, but it's something you have to bear in mind if you use open search engines. And of course, a lot of information is not available, is not accessible, because more and more publishers are aware of the value of their content online. And they don't put it anymore online, or it's very hard to get it, and you need to go directly to these publishers to get it, or use aggregators like us. And last but not least, people, and excuse my French, bullshit a lot on the internet. And these so-called personal profiles on LinkedIn are in many cases very incorrect and mispresenting actually the person. So you need to be very careful in using social media profiles to get a sort of a sense for a person. Actually, I have a question around LinkedIn and personal data. For me, it's not clear if we can use those profiles in our database. So we are not doing it because there is no clear definition if that is data you can use or not. Well, this is more or less the end of my presentation. Just one big lesson we have learned implementing our processes, and I've seen this many times with customers, is that if the CEO, if the top of an organization is not bought in implementing these processes, it's doomed to fail. So it's really, really important that not only lawyers are worrying, are concerning about this kind of issue, but also the business leaders should get this in their heart.
Роб, спасибо большое.
Thank you very much, Rob, for your presentation. In the end, you said about the role of CEOs or of the roles of the top management when it comes to anti-corruption efforts, and that's what made me think that I was looking at Rob and I was thinking that if we had a panel on this forum consisting of the CEOs of large companies, and if they were to discuss the importance of compliance in Russia, then I think then we would be marked in a different color on Rob's map when it came to, on the map of Transparency International. So probably the management of the company that sells legal information, they probably get really saturated with this information and they almost become lawyers. But still, thank you very much for such an approach of a CEO. We really, each lawyer wishes to have a CEO like you. So, dear colleagues, Rob told us about their system of checks that they use to check third parties. And let's say LexisNexis gets a monopoly on the market when it comes to on the Russian markets, of the Russian database markets. You have a monopoly in supplying legal data, and then LexisNexis should go directly to Mr. Puzurevsky because he has his own point of view, which he will tell us about because he comes from the regulator. Thank you very much. It was an immense pleasure for me to listen to all the speeches related to compliance implementation in corporations. And of course, all of the questions raised, they indicate that it is not so simple in Russia, that nothing is smooth and easy. And I would like to touch upon one of the aspects, which is the relation between anti-monopoly laws and adherence to anti-monopoly regulations imposed on public companies. And first of all, we face this issue as soon as international anti-corruption measures were set in motion, and as soon as we had to start proceedings about the terminating of contracts with international companies. And I think that the first fork in the road in the relationship of the anti-monopoly and anti-corruption legislation in Russia, first of all, is the fact that we didn't have an opportunity to sign agreements with business partners. But I can say that Russia has several ways, several approaches in place on determining a monopoly situation on the market. So theoretically, a company whose share exceeds 8% might become a company which has to adhere to certain limitations. And here we have to talk about the procedures which could be used for onboarding without violating anti-corruption legislation and without being criminalized either in the UK or in the US. So the first issue that we face is what is the basis for a company to refuse a business partner a contract. And here we can say that the fair competition law says that a dominating company can refuse signing of a contract if such a refusal comes from economic or technological reasons. And this is all. This is the only option. Therefore, one of the cases that was reviewed when we reviewed the refusal, it was related to a company called Novo Nordisk, who refused signing a contract under anti-corruption efforts, who refused a contract to certain distributors who worked in Russia. As a result of very lengthy negotiations, and of course, once we started discovering how it was done, we saw that there was no system-wide approach. We managed to lay down some principles which were later used by other companies. So if we say that there is a possibility to refuse a contract, then if we're trying to adhere to the legislation, then we have, of course, we have to filter certain business partners. Say, if we have certain categories of goods that cannot be sold to certain groups of customers, for instance, we cannot sell arms or guns to everyone. So if somebody who has a monopoly on this market sells guns to somebody else, then they would violate the law. So here, again, what we have to do, we have to lay down very clear and precise criteria that would limit business partners who do not act in good faith. And based on that, once we make these approaches publicly known, we can proceed to signing of corresponding agreements, and we can proceed to building our own network of business partners. Here we come to the second fork of the road. What sort of criteria should we develop? Well, this question, in any case, in the legal profession and among corporate representatives, this question gain a lot of momentum as well. So how do we determine whether a company takes part in corruption if we do not know much about such company? Say they look suspicious to us, so maybe they can bribe somebody. So if we do not have a well-grounded basis, then we cannot lawfully refuse signing a contract with them. So we have to list specific factors that prove that the company partakes in corruption. But if we have certain information that gives us evidence of company participating in bribery or corruption, then of course it would give us a legal basis. And then that's where we came to a dead end, because sometimes we would see a publication somewhere but there were no criminal proceedings. And what if the dominating company published this article so that they're not associated with this business partner? And one of the options that we are discussing right now, and it will probably brought in front of the State Duma in the near future, we think that in order to eliminate a possibility of a wrong relation or wrong ratio between anti-monopoly and anti-corruption law, it's better to set certain criteria for onboarding. And I think that if we go back to Novo Nordisk published these rules, and the anti-monopoly service was extremely happy with the rules that they developed. But within the framework of this legislation, we propose not only lay down the criteria that would validate it, but also in order for the anti-monopoly service not to decide it on an ad hoc basis, because a business partner that was refused a contract, the first thing that they do, that they apply to the anti-monopoly service with a request to look into it. So we would have to decide on an ad hoc basis whether the information is real. So we decided to shift this responsibility to the courts. So a company should announce publicly that they refuse signing a contract with a business partner, and then a business partner has a right to defend its good name in court. If they manage to prove that it is not true, then we'll have to sign a contract with them. But actually, we do not have severe consequences. If we talk about the situation that was 1 year ago and we had a severe fine for the violation of anti-monopoly law, but now we have so-called soft regulations. At first we have an anti-monopoly service issues a warning and the company will not be penalized monetarily. Therefore, if we manage to implement all of these provisions, then we will be able to reach significant progress, and we will reach a very good balance and a very good ratio, and we will be able to contribute to very good understanding, very good corporate understanding of the relation between anti-corruption and anti-monopoly law. That's why we
welcome any compliance-related activities, because in any case it facilitates competition. Thank you very much. Thank you, Sergei. Publishing trade practices or public announcement about reputational grounds for refusal, those are, of course, wonderful tools. Not always you can directly tell your counterpart, I don't trust you. In business, it doesn't often work. But there is probably no other way to guarantee these two very important things, such as the absence of corruption and the absence of violation of anti-monopoly legislation. Requires us to strike a balance, to find a trade-off, a compromise. And here I think that the anti-monopoly service is prepared to talk to the business community impacted by those norms. We would like to hear your initiatives when they emerge. We would like to be able to discuss them at various legal fora, the Cura and other places. Our draft is with the Cura now. There is a compliance conference in Moscow today. We have to participate in it as well. So we are prepared to discuss these issues in various formats. So there is always room for improvement. Thank you, we heard that. I think there are lots and lots of companies who are influenced by all these issues, not only international companies but large Russian companies as well, and maybe we will be in touch with you and we'll probably hold a roundtable discussion to make sure that we do not have any problems with one another, and it's not going to influence the international aspects of this problem, because there is a trend with our US partners to think that Russian legislation is used as a way to keep something secret, something bad secret. Yeah, we had to have a discussion with the Ministry of Justice of the US, and we found common understanding, so there won't be any attempts to say that someone is trying to hide something. In the Ministry of Justice and the Department of Justice, they also have regulations that are implemented by other people. It's very difficult to put everyone on the same page. Thank you very much to be engaged, for being engaged in the dialogue as an anti-monopoly service. This is one of the regulators which is prepared to hear the business community and public at large. So we will continue this dialogue. Dear colleagues, We are done with the presentations. We are lagging behind the schedule, but still we have about 5 minutes to answer whatever questions you may have. Or that is it. I can ask a question if they're... Okay. Those who are very hungry can stand up and go have lunch at any time. I have a question to Boris from Roskomnadzor. Nothing personal, only business. All those correct things that you were talking about, when are they going to be implemented? I understand that this is a super trivial question, but do you understand when all of this is going to be implemented? The creation of regulatory acts and their adoption in the State Duma is a lengthy process. Our colleague from the Anti-Monopoly Service can confirm how long can it take to have a draft law adopted. Amendments to the law on personal data and amendments to legislation related to the ratification of the European Convention, they were under consideration for more than 3 years. Well, I have personal experience of dealing with your organization. It's not positive. Don't want to be hurt, but this is so. When I was working for the Sberbank and we came to you and we put up on our site a list of persons whom we fired for reputational reasons, and I heard only threats from your organization. You threatened to take me to the prosecutor's office, but since you're here, you were not taken to the prosecutor's office and further to jail. And if you continue asking similar questions, I won't be sure of your remaining free. So, Boris, I think that the situation is like this, that we adopted this legislation in a hurry. Then we introduced sanctions all the way to criminal liability. Make a simple exercise. Try to come to a commercial bank and find a person who would be prepared to undertake to oversee the compliance with personal data law. It's very difficult because on the one hand, everything is in place. We have all the sanctions in place, all the way to criminal liability, and people are just frightened. You cannot explain that criminal liability ensues only for certain infringements. Very often, if we continue like this, we will end up in a situation described by our singer Boris Grebenshikov with the words, "What shall we do with this drunken sailor?" Okay. Well, this is not a question, actually. This is a request. For us, for the business community, for the banking community, this is not only an issue of growing of administrative and operational burden, which doesn't generate profit. But this is a cost center. This is quite clear. But this is also an issue of psychological approach. This legislation is new, and not everyone knows these laws very well, but the sanctions are huge, and there is a feeling of this, a very uncomfortable feeling. In my presentation, I tried to tell you that we do understand that certain norms are excessive. Those, norms regulating the processing of personal data in the banking sphere is one of the sectors which comes across these issues directly. We're now talking to communications operators about this. I think that such issues can be raised with the banking community as well. And we can propose various self-government, self-management to self-governance institution in this field. And in this way, you will alleviate the burden of government control. I'm not sure that within the banking law we will be able to get rid of this topic at all, because it is quite sensitive, but this trend is initiated by us, or will be initiated by us in the near future. So I think that there is a need in a roundtable discussion where the banking community could lead the way and make their proposals to that effect. Mr. Kabakov is prepared, I think, to do this. You have your own ideas that need to be communicated. Boris, I invite you, and I think that within the CUA we can help to organize these meetings. Unfortunately, well, so if you are going to invite people so emotionally, do you think Boris will come? No, he won't. He has come when we invited him. Okay, dear colleagues, completing this panel discussion. One question, okay. Please. It doesn't work? Microphone, please.
Казанцев Денис, заместитель.
Denis Kazantsev, Deputy General Director of Mosenergosbit. I have a question to Sergei Puzyrevsky. What we're discussing here today, well, and actually when I come back to my office on Monday, I would probably think that I had been on a journey to a different planet. Because in Europe, compliance, anti-corruption measures are very well developed. In Russia, we are making just very first steps in this direction. And when our colleagues from Europe were listening to Anton Smirnov's presentation, and he was saying that you need to, well, they thought that we should fire any, you can fire any employee who is related to corruption, but when he said that you can fire only those employees who are either drunk at workplace or are absent from the workplace for more than 4 hours, and that's it, only 2 reasons for firing people. So, but I would say many infrastructural organizations, for us, the anti-monopoly service is our main counterpart. Everything that we do when we consider an application for a contract, we think about the requirements of the anti-monopoly service. Any refusal on our part will probably be an infringement. This is the way the legislative basis is formed in Russia and probably elsewhere. So why was I talking about the journey to a different planet? Let's fantasize about some long-term future when we will be fighting corruption as they do in Europe now. Sergei, do you see any possibility for the providers of utility services or power suppliers for whom all the contracts are public? Can they use compliance if they refuse to sign a contract? You've asked a very difficult question. Thank you very much. Yes, of course. The approach you are talking about and issues related to infrastructural monopolies, related to power supply companies, they will require a special ad hoc solution. Because you participated in something and now we will cut off electricity for you. It won't work probably, no. Everyone has the right to life. Then they will cut off electricity and then you will go to the court of law to complain, okay, yes. But what I was telling you about were situations which are related to dominating but not monopoly structures. With monopolies, the approach probably should take into account some other parameters as well. I can tell you that now, when we are discussing those amendments, we are prepared to have a separate meeting on this topic, actually, especially the utility sector and everything related to power supply. Requires a separate approach. But if the proposal that we are currently formulating is adopted for specific people who are not related to entrepreneurial activities, they are not going to be covered to anti-monopoly legislation anymore, but there will be other norms regulating compulsory connection to networks. I won't be able to give you a specific solution right now. Well, we must go and have lunch now. Thank you very much. I would like to thank all the participants. There are different planets, and I hope that we will end up on one and the same planet sooner or later.